May I please, Lordship?
Yes.
Lordship, I beg to mention item number 4.
Hmm.
Due to personal difficulties, leading counsel D. Panging is unable to appear today, Lordship. Due to personal difficulties, leading counsel D. Panging is unable to appear today, Lordship.
Item 4.
Yes, Lordship.
Yeah.
Kindly list this matter after weeks, Lordship.
Next week, Your Lordship. I'm for the respondent, petitioner, Your Lordship.
Sure. Any objection?
Next.
Yes, Lordship.
Next week.
Yes.
On the prayer of Mr.
T. Darin.
T. Daring, Learned Counsel appearing on behalf of Mr. D. Panging, Learned Counsel for the respondent. On the ground that Mr. D. Panging, Learned Counsel to the Learned Counsel is indisposed. Come on. Let this matter be listed after a week. MS. Learned Counsel to the petitioner is present.
Okay.
Lordship, I beg to mention two pending matter regarding anticipatory bail for listing tomorrow.
It's a new matter.
Pending matter.
Why? It will be listed on its own third.
For tomorrow, Lordship.
No, when it was filed.
Lordship, conducting counsel, he's occupied in court one. He told me to.
This has already been filed.
Yes, Lordship.
It's a new matter or pending matter.
Pending matter.
Pending matter, you just check. It will be listed as per the thing. When is it supposed to be listed?
Tomorrow.
No,
Oh.
as per the last order.
Last one. Yeah, Lordship. After last one. Supposed to be listed after 2 weeks or.
It will be listed after 2 weeks only.
Yes, Lordship. Okay.
If it is not listed, after 2 weeks, you make a mention with the order, last order,
Yes, Lord.
right?
Yes.
If it is not listed, even after expiry of 2 weeks, you come up, you make a mention with the last order.
Yes, Lordship.
Right.
Yes.
May it please, Your
Yes.
Lordship? Your Lordship, I beg to mention item number 8, Your Lordship.
8.
I'm for the petition, appellant, Your Lordship.
Hmm.
I have checked the records. The service report is yet to be completed, so it's still awaited. So I may be allowed to take fresh step upon the sole respondent.
Mr.
N. Kaku.
N.
Kakum.
Kakum. Your name is not there.
It is there in the
Item 8.
item 8. It is there in the cause list.
Kakum. Okay. N. Kakum.
Yes, Lordship.
Learned Counsel for the appellant submits that he may be permitted to take fresh steps upon sole respondent.
Yes.
Accordingly, the Learned Counsel for the appellant is permitted to take fresh step for service of notice upon respondent. Service of notice upon respondent within 2 days.
Yes, Lordship.
List after 4 weeks.
Yes, Lordship. Deeply obliged, Lordship.
May I, Lordship?
Yes.
Lordship, this is a pre-arrest bail. The petitioner before this honorable court is Lordship. He is a senior citizenship. Just retired from education department.
Where is the FIR?
FIR is in Lordship. It's in page 15, Lordship. May I read, Lordship? Before FIR against Sri Lika Service, one of so Jolang, so and so, mobile number so and so, for forging official documents. It says, Lordship, with reference to above cited subject, the undersigned would like to inform you that so and so while applying for land possession submitted and no object.
Yes, heard, Mr. Bija, land counsel for the applicant. Yes, what do you say?
Notice may be issued and Lordship, this is 468 Lordship, or 424/68, then he may be allowed to appear before the IO to
Okay,
submit his statement.
MS El Hage. No, this is an application under section 482 of BNSS 2023, praying for grant of praying for grant of pre-arrest bail to the accused applicant in connection with Ethanol PS case number 214 of 2024 under section 420, 468, 471. IPC. Call for the case diary. MS El Hage Learned Additional appears an exception notice on behalf of the state. In the interim, in the event of arrest of the accused applicant, he shall be released on interim bail on furnishing a bail bond of rupees 10,000 with surety, one surety of like amount to the satisfaction of the investigating officer listed. On the following conditions, you just give the condition, the petitioner shall, the accused applicant shall appear
Yes, ma'am.
before the investigating officer within 7 days from today. He shall cooperate, so and so, huh? You just give those conditions, 3 conditions, that's all.
Next, next
There
step,
appears to
Lordship.
be a
Next, Lordship. 28.
land dispute.
And next,
Appears to be a land dispute.
Yes, Lordship, already I have LPC has been given
Yes,
to me.
I've seen it.
Without cancelling my LPC
List the
also.
matter after 2 weeks.
So it's-
2 weeks.
Yes.
I will fix that. List the matter on 4th.
4th of December.
4th of this.
Deeply obliged.
Right.
I beg my pardon, Your Lordship. Your Lordship, I have forgot to mention that there is a entry in item number 8, Your Lordship.
Yes.
It may be continued. Obliged.
This is an, heard Mr. M at the Learned Counsel for the petitioners. It's a joint petition.
Yes.
And, you call for the record, scan copy. Is the charge sheet has been filed?
CD already enclosed here in the
Yes.
petition.
This is what?
This is a
Washing.
washing.
So how you have the advance?
No, here, the charge sheet was already enclosed, copy of charge sheet.
Okay.
And
Already
this is a case of student and teacher.
But
So the
that's
union,
why we'll just call for the scan.
they have arrived into compromise settlement.
Yes, yes.
And strict stand condition was imposed upon them also. They were debarred from taking admission
Yes.
in future.
So what is to be done? It's a motion, we'll call for the record. Next date we'll see.
Yes, it can be done.
That's why I'm saying, why you are having that advance record? Even the notice has not been issued.
Oh, they have supplied to us.
You know,
It's okay.
appearance already.
Heard Mr. M at Learned Counsel for the petitioner. Petitioners,
Yes.
this is an application under section 528 of BNSS 2023. Jointly praying for washing of the criminal proceeding in connection with GF case number 849 of 2022 under section page 1. Right? IPC, read with Section 3 of PDPP Act 1984. Charge sheet has already been filed.
Yes.
Call for the scanned copy of the trial court records. Which court?
See, Gem FC, it's pending in Gem FC.
From the court of
Yup.
JMFC,
Yeah.
UPIA.
Yeah.
JMC, Judicial Magistrate First Class UPIA. Just before that, on the basis of the settlement, between the petitioners. Mr. Jita, learned addition PP. appears and accepted notice on behalf of the state. Pending production of the scanned copy of trial court reports. Further proceedings of GR case number 849 of 2020 shall remain suspended. List after 4 weeks. Heard Mr. M. Boje, Learned Counsel for the Boje, Learned Counsel for the petitioner. Petitioners. Explain. Same application, this is an application under section 528, so and so, so and so. Bring for question of FIR number, FIR dated 02/03/2022. Being Itanagar WPS case number 33 of 2022 under section 376, 323 IPC.
No, see,
Jointly.
already charge sheeted, no.
Huh?
Not subject.
No,
Jointly
already.
filed by the petitioners on the basis of settlement. Mr. Call for the case diary. Case diary.
No, see, yes, no, see.
Call for the scanned copy of the case diary. Mr.
Otherwise also not safe.
Call for the scanned copy of the case diary. MS L. Hage Learned Edition PP appears for the state. Appears and accepted notice on behalf of the state. List after 4 weeks. 4 weeks.
No, no, sir.
3 weeks.
It's an emergency case, sir.
Not an emergency. It's a 376, sir.
Very urgent.
376 case.
After three, after
Three,
1
after
week.
3 weeks.
After one week.
Why?
After 1 week. Urgency is there, boss.
Sir, 376.
After 1 week.
It's
Because,
a 376 case, sir.
of course, but there is a mutual settlement also.
And then you cannot.
And they are family relative, close family relative.
cannot.
Otherwise also, in this case, case diary is also, I believe, is not necessary. Because the FIR itself, the settlement itself says it was falsely, they have lodged an FIR. Even he was arrested. And as per the police report also, there is no, case is not made out.
We'll see. We'll see. That's why we're calling for the case diary.
Case diary is pending before this CGM, JMFC.
Why? The charge sheet has been filed.
No, it's no charge.
Final report.
Yes.
Final report.
Yes, it's just a report.
So from where we should call the record? CGM or case diary?
Then after 1 week also.
No, you first tell us. Where is the record? From where record has to be called? You tell us where it is pending. It's before the police or before the magistrate.
A report is,
Sir, it's 376.
yes.
Right, number one. Number two, would like to see the record. Where is the record?
Record is with the court, lower court,
Which court?
JMFC.
So we'll call for that. We'll see.
Yes.
If there's nothing, we'll see. We'll pass
After
it.
1 week.
Not 1 week.
It's only here only.
Doesn't matter. In that case, after 2 weeks, we'll see.
2
Because we're
weeks.
not granting any interim.
Hello.
376 we're not granting, therefore we're fixing it after 2 weeks. All right.
This is for washing only, Lordship. Here, bail is already
Sir,
granted.
washing, it's a case offense alleged is 376.
Yeah, Lordship.
So
It may be taken up one after
you
one.
cannot compromise. On the basis of your compromise, 376 and the POXO case cannot be quashed just like that. So we'll see the record.
Was invoking.
You just tell us from where we should call the records.
Lordship, here, Lordship, on the 14/11, Lordship, before the JMFC, they have bail bond, Lordship, they have applied for the bail, Lordship. Then after that, Lordship, bail is.
He has been released.
Yes.
Now he has been released.
Yes, I have.
Then the case diary may be returned. back.
Exactly.
Sir, why we're wasting time? From where the records should be called? You just tell us.
Yes.
From where? It's from
the-
the police station, case diary, or from the judicial magistrate first class?
See,
Where?
It may be returned back to the police PS, Lordship, because they have only applied for the bail, Lordship. So we call for the case diary from the PS.
You simply tell us from where the records should be called. According to you, there's nothing on the record in the investigation, in the case diary. You are saying so.
But that is fine. Record may
That
be
is
called
not
as-
fine. You have to tell. We'll call for the records and we'll see. You
case
just
diary-
tell us.
If at all case diary is necessitated, then it had to be called from the police only.
Yes.
Yes.
You said that records are with the magistrate.
Actually, file is here. Pen. with-
Any FIR has been filed.
Yes.
FIR has been filed.
No, not exactly.
Any final
It's only-
report?
It's only a report, police report, that's all.
I don't know.
Lordship,
You find it out. We're fixing it after 2 weeks. We'll calling for the case diary. Because you have said nothing, no charge sheet, nothing has been filed.
Lordship, it will be too late, Lordship. I'm very poor man. I cannot afford to stay here at Arunachal. I'm all the way from Uttar Pradesh.
He doesn't have to be here. You are here.
I have been for the last more than 2 weeks. I have been here. I'm facing problem.
You are there.
Yes, I'm here only at the UP.
You are the mouthpiece of your client. So you are here. Are you going with your client to Bihar or UP?
Because I have a small. This petitioner number one having a small children, three
That's-
small children.
That's why you have been granted bail
Yes.
in 376.
So therefore,
Yes.
my only prayer would be case diary may be called for within 1 week. It's near only.
After 2 weeks.
2 weeks will be too late.
Why?
Too long it will be. I'm really facing hardship.
I'll pass it order. The learned counsel for the petitioner did not detain the petitioner at Itanagar. We'll pass the order.
No, Lordship, I am already released on bail.
So
Pair one on.
I am saying learned counsel for the petitioner shall not detain him at Itanagar. Since he has been released on bail, let him roam around freely. We'll decide the quashing. We'll decide the proceedings in his absence.
It would be more appropriate if it is within 1 week, Lordship.
What appropriate? We're looking at the appropriateness of all considering all the situations.
Because I am facing
List after 1 week. Anyway, call for the case then. Huh?
life.
Yes.
My lord, if I may, my lord, this 42 is challenging two orders passed by the learned Judicial Magistrate First Class UPM. The first order, impugn order is 2702/2020, whereby my maintenance was stopped because they have obtained an ex parte decree of restitution of conjugal rights against me.
Yeah,
And the second order is 5/9/2023.
where is the law? Where is the judgment?
Order.
Where is that judgment?
The order is at page number 14, Your Honor.
40,
14, Your Honor.
14.
Yes, Your Honor. The impugn order, first impugn order.
Yes.
Basically, if I may read, Your Honor, from page number 15, the portion. It also appears pertinent to mention here that the judgments in so and so and in the case of so and so, which refers to the effect of an ex parte decree for RCR relied upon by the respondent applicant will not entirely apply in the present case, even though the instant decree
What is
of
RCR?
restitution of conjugal rights
Okay.
is also an ex parte one because it is evident that Srimati Rashmi Rekha, the petitioner herein, even after having knowledge of the RCR case filed against her, failed to take the appropriate steps, and in this regard, it cannot be denied that she ought to have knowledge of the consequences of in the event of a decree being passed against her. In the light of the aforesaid consideration and in the presence of a decision of a competent civil court, the prayer of the applicant respondent is allowed and the interim maintenance order dated 2/9/2019 is hereby cancelled under section 127, subsection 2 of CRPC. Now, this is the first order. This was, my maintenance was cancelled because they have obtained an ex parte decree of restitution of conjugal rights. Now, the second order is annexure 2, Your Honor, which starts at para 17.
Page 17.
Page 17. It starts on page 17. The operative portion is page 19, Your Honor, the last para. If I may read, Your Honor. I have considered the submission made by the councils on both sides and perused the record. Also perused order dated 27/02/2020, whereby the interim order was cancelled by this court. This court has discussed the effect of ex parte decree for restitution of conjugal rights as applicable in the facts and circumstances of the instant case. I am of the considerate view that the applicant petitioner has not shown any satisfactory grounds for alteration of the order of this court. The instant case is in the stage of evidence, and the fact whether the petitioner has failed to reside with the respondent without any valid reason can only be ascertained after adducing evidence. Accordingly, prayer of the applicant is rejected. Now, Your Honor, our ground for challenge in the instant petition is, Your Honor, that my lord, that firstly, Your Honor, my lord, that if an ex parte decree is passed for restitution of conjugal right, it has been consistently held that unless the specific point is made regarding whether the incohabitation between the parties is because willfully done by the wife, that would not bar a magistrate court to pass a maintenance order under section 125. And especially in the case of ex parte decree, even if the decree of restitution of conjugal rights is passed, if there is specific order, if issue has not been framed by the learned court, then there is no bar upon the magistrate to exercise the power under 125. And especially in the case of an ex parte RCR decree, my lord. That is the basic framework under which we are arguing. My lord, in that regard, I had relied on the judgment by this our Guwahati High Court, my lord.
Record is there. Record. The record will be required.
I was under the impression report.
Yes, my lord, actually, lordship, petitioner, they're supposed to file a rejoinder and they have taken so many times for rejoinder, but they have.
It's a revision, it's a
And
criminal
lordship-
petition.
lordship,
We'll call for
petitioner-
the records and we'll see.
Yes, my
Heard
lord,
Mr. Jeet alone.
petitioner have a
Petitioner.
alternative remedy, they are.
And
challenge-
also, Mr.
And Rama, my lord.
N. Rama, learned counsel for the respondent. Call for the scanned copy of the trial court record. Mr.
Lordship, there is an interim order of 8,000.
Petition. Huh?
Interim order was not continuous as earlier order, my lord.
It's okay, we'll continue. But they, what is the interim order?
8,000.
8,000 per month, I have supposed to pay the petitioner, as I'm a husband.
Where it is? By which
It
order?
was the first order, my lord. In the month of November. 22/11, my lord.
In fact, my lord,
You pay.
petitioner has not come with the entire fact of the case and they have mislead the honorable
We'll
court.
fix after 2 weeks. From where are the records?
The learned JMFC.
Not
UPI.
as- UPI.
We'll fix after 2 weeks. You pay the interim as per direction.
Yes.
Call for the a scanned copy of the trial court record from the Court of Judicial Magistrate First Class UPI,
Yes,
right? List the matter after 2 weeks for admission hearing. Admission hearing,
yes, my lord.
Yes,
the respondent is directed to pay the interim maintenance as directed by this court. That is 22/11/2023. Forthwith,
Much obliged.
you pay the maintenance.
yes.
May I please, your lordship?
Yes.
Lordship, the instant bail application is filed for enlargement of the accused person in connection with Itanagar.
Why you have mentioned the matter is to be listed on 19 December?
Lordship, since this matter has been pending for the past
It is there.
2 months.
This year,
This year, trial court record.
Your lordship, here for victim A and victim B, this is POCSO matter. Legal aid counsel was appointed, one Miss Jaya Doji, and this her letter of absence is there in the cost list.
It's not shown. Is it shown? Is it reflected?
Yes, it is reflected. Her letter of absence is reflected in cost list.
Whatever the state service on respondent? Legal aid counsel has been appointed
Yes,
on behalf of the respondents,
yes. Miss
Respondent two.
A and Miss B.
2 and 3.
Yes, 20.
Her name is.
Last order, it said, expert for this the matter 1912. Today is 1911,
Lordship.
2011.
It was mentioned because, lordship, it has been pending for the past 2 months, lordship, almost 2 months.
No, last order 8/11 you have made a mention. On the prior the parties only, this was listed on
Lordship,
1912.
thereafter, yesterday it was mentioned before this honorable court.
That's why we have reluctantly accepted this.
Lordship. In that case, lordship, should be, no, I am aware of this.
This matter has,
Lordship,
this matter has come up on being,
just a small
on the
submission,
mention
lordship.
of the learned counsel for the applicant. Mr. It is said that it is said that on 8/11/2024, this court on the prayer of learned counsel for the parties, the matter was listed, has been listed on, listed for 19/12/2024. However, Mr. A. Thatak and Mr. Gita, the learned counsel for the applicant, learned counsel for the applicant and Mr. Gita, the addition PP submits that there's a inadvertent mistake in fixing the date on 19/12/2024. As they were under the impression that the matter is listed for 19/11/2024. having considered the submission and also and considering that the copy of trial court record has been received, let this matter be listed after 1 week, after a week.
Be on 25th, Lord, 25th.
25th, you have to come to my residence. We'll conduct the hearing there.
26, Lordship.
I'm ready, you may join in the chamber there.
Lordship, maybe please to give a fixed date, Lordship, then.
3rd of December,
Lordship.
3rd of December. It's POXO.
Yes, boss.
Lordship. But
It is very, very likely or very unlikely that you'll be released on bail.
Lordship,
Therefore,
yes.
3rd of December.
Yes.
By this court. Yes, 3rd of December.
Lordship. Deeply obliged.
Obliged.
May I please, my lord?
Yes.
My lord, this bail application is filed in connection with Nahalagarh, sorry, Demo PS case number 86/24 under section 103, subsection 1/3, subsection 5 of
What is this?
BNS.
What is this?
My lord, section 103 is a murder section, punishment of murder, BNS. And section 3, subclause 5 is common intention. So before I made submission, Lordship, I would like to read out the content of FIR, madam. Our FIR is page number 12, madam.
Teacher
11.
record has not come, Lordship.
It's before.
HCR was, charge sheet already filed as it's informed by the London session. court.
Charge sheet has already been filed.
Yes.
We'll
As
call
per
for
the-
the next week, we'll take it up. But you have admitted, you have accompanied with him.
No, no, my lord,
At the
I
time
was accompanied during the day of incident.
You tried to
And-
say that after meeting him, you left the place.
Yes, what?
Then you came to know at 11:30 and police has come to.
Yes, my lord.
That's all. It's hard
And my lord,
hard to believe.
whatsoever incident happened, it was unfortunate and that disease was taking overdose of contraband substance and because of that she.
103, we'll see next week. Can you, next week?
But, teacher record may call for the.
Okay.
court,
Heard
Lordship.
Mr. N. Rama, Learned Counsel.
Session
for
from
the-
session court, Lordship.
Special court, UP, my lord.
For the applicant. And also Ms. Elhage Learned, additional PP for the state. It is informed that the charge sheet has already been filed.
Yes.
Next paragraph. Having considered these submissions, let the scanned copy of trial court record from the Court of Sessions,
Yes, madam.
from the Sessions Court be called for. List the matter after a week. 27, 27, list the matter on 27/11/2020.
My lord,
Or third or fourth,
um,
fourth. 04
my lord,
12.
3rd December. 3rd December,
Make it, we have picked so many matters on third, make it fourth, 04,
4th December.
04 12 days.
Much of.
Right.
This is. IA is for what?
I is for the granting, paying for granting bail. For the pending. Lord, this instant. Appeal has already been dealt with by the Honorable Court. During the pendency of this case, as per section 389(1) of the CRPC, for the interest of justice, at least bail may be granted to the convict. And the bail is filed by wife of the convict. And the operation of the order dated 11/6/2024 may be suspended, and I will please to grant bail Because there is no question of tampering of evidences and witnesses, everything has been done. And I have been convicted under 448 IPC, 448 IPC is 6 months.
With the IU. With the IU.
Punishment of
This has been already admitted.
Yes, bro.
We fix it
Punishment-
for hearing. After 2 weeks.
During the pendency, at least operation of the order dated 11/6/24 may be suspended and it's as a statutory right may not maybe they may be granted during the pendency. Because punishment, highest
Sentence?
highest sentence is under 367,
Hmm.
3 years, 1 month only.
Hmm?
3 years, 1 month only. Under 448, 6 month fine of rupees 1,000. 323, 6 month fine of rupees 1,000. Under 365 IPC, 2 years fine of rupees 10,000. And 367, 3 years, 1 month only. And fine of rupees 1,000, 10,000. So punishment and the offense is also not heinous offense. So the hearing will take time. But any terms and condition may be imposed for granting bail for the pendency of this appeal.
Service already completed. In respect of R2. He may be given opportunity to appear on next date.
Who is?
Complainant.
Service completed.
Yes, completed.
Service is complete. So from what you were saying,
In IA, he has not implemented the complainant.
here,
In main appeal, he has.
no, IA is there. Dekinori cutoff. Right?
Yes.
Yes, a complainant. In main appeal, he implemented, but in IA, he has not implemented.
IA is also it's impleted.
In my copy, there is.
9/8/2024. Amended course title.
Oh, it was not supplied. Furnished to me.
Notice has not been issued.
Notice issued. Bro.
Well, you are saying that it has been completed, the notice has been served.
As per office note, it is reflected.
Where it is?
As per office note.
What is your grounds? What are the grounds?
So
Of release on bail?
ground secretary, Lord, the PWs, there are lots of contradiction and weak piece of evidences are there. And I have a case. If we look into the FIR also, FIR was lodged by the complainant alleging of the incident on 21/9/2016. But during the course of trial, the victim, he himself has said that the incident was of 2000, incident was of 22. And even the complainant could not able to identify the accused during the course of trial. And even, Ali, I will take you to page number 149.
149.
Yes. The positions of the complainant. Last line, point number 6. I do not recognize the person standing on the top, but in the FIR, he has specifically mentioned the name of the accused person. But during the course of trial, he could not able to even identify. And the statement of PW2
149 of what?
149 of
IA.
yes, yes,
IA 70.
yes, IA 70, yes.
149 doesn't say anything. You just read. Where you are reading? Where you have read?
Para 6.
149.
Yes, 149.
Typed copy.
Not typo.
149 is some typed copy.
Yes, type copy.
149 is a typed copy of 148.
It's a statement of eyewitness. Case of abduction and assaulting.
We'll fix after 2 weeks for the hearing. And in the case if it cannot be taken up, you press for the IA, press your IA. We'll fix after 2 weeks. Or Mr. G. Lawler, counsel for the appellant. Applicant or appellant. And also Mr. G. Tadab, counsel for the additional PP for the state. Service in respect of respondent is complete. And the paper book has also been prepared. Since the appeal has been admitted. List the matter for hearing on after 2 weeks. Hearing after 2 weeks. On the next date. In the event the criminal appeal is not taken up for hearing. The counsel to the appellant, public applicant may press for consideration of the IA or release of the public appellant on
Lord,
bail.
Otherwise, 1 week, because everything is there, when the paper book has also been arrived. so
Let us
it's
make it
1
to
week.
2 weeks.
Obliged.
9 and 10, right?
Yes, 9 and 10.
You make it separate order.
May I please, Lordship?
Yes.
Service report is still awaited, Lordship.
Await service report. List after.
Your Lordship,
Interim
interim may
order
be
for earlier shall continue.
much obliged.
Your Lordship, we need,
Take steps, press steps. Not press steps. You have not taken steps only. Mr. So-and-so, learned counsel for the petitioner is granted further, granted further 2 days time to take steps for a service of notice upon
Lordship,
respondent, list after 4 weeks.
Lordship, interim.
Interim order was earlier.
My lord, this matter is for the first time. It's an appeal against the conviction. In this case also, my lord, this matter has been listed in orders, my lord, for the reason that there's a delay of 23 days,
You should notice.
my lord. Otherwise, my lord, only 23 days.
Registered, huh? 25 days.
25 days.
What is the offense? NDPS.
NDPS, convicted for 10 years.
What do you say?
Delay can be explained properly.
It has been explained properly. Where is the explanation?
The IA, my lord, the judgment was pronounced on 27/8/2024. And after 2 days, my lord, if I may take my lord to page number 48, we have applied for the certified copy. My lord.
Where you have given that? In IA.
IA, my lord. My lord, paragraph 6.
Hello?
Yes.
Heard Mr. Jayasri, learned counsel for the applicant. And also heard Mr. Jithado, learned counsel for the learned additional PP for the state. Next paragraph, this is an application under section 5 of Limitation Act 1962 for bring for condemnation of 25 days delay in filing the condemnation of delay of 25 days in filing the connected appeal against the judgment and sentence ordered dated 27/08/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDPS Momdila in 20 / 8/2024 passed by the special judge NDP What is the case number?
NDPS case number 13 of 2023.
NDPS case number 13 of 2023. Being considered the grounds. Having considered the grounds taken in the application for delay in filing the connected criminal appeal, and also we are not being opposed by the learned additional PP. I deem it appropriate. I'm of the view that the applicant has shown sufficient cause in filing the appeal within the limitation period. Mr. Accordingly, the delay of 25 days in filing the connected criminal appeal is unknown. Mr. The application, the application is then allowed in disposal. It's already numbered.
Yeah. The main appeal, my lord.
It's not here. Main appeal is not here. We'll see. At least the appeal. At least the criminal appeal. No, it's not here.
Good morning, madam. May I please, my lord? I have filed one criminal petition under section 482 of the CRPC
Yes,
for quashing of the your FIR,
second FIR.
second FIR.
You show us, it's one and the same.
My lord, the FIR, two FIRs has been lodged. One is lodged at Rowing, Lower Dibang Valley by one student union regarding the same incident, and one is lodged at Sadia Forest Range Office for the same offence. Now, the Sadia Range Office already submitted prosecution report and the case is
So that is Sadia is Sapakana.
Chapakwa.
Chapaka.
Chapakwa Sadia Tinsukia.
That is some different place,
Different places.
area. You have offense you have committed there.
But for the
also.
same offence, my lord.
But you have committed there also at Anini.
But that is as per the mandate of the section 55 of the Wildlife Act, my lord. That is not lodged by
No,
any
that,
private.
no, that is different thing altogether. You
Yes,
are
ma'am.
saying that on same offense, same
Yes.
incident.
Yes, my lord.
There are two FIRs.
Yes, my lord.
But the record says shows that that Japuakana incident or the offense which you alleged to have been committed is a different
My lord,
thing.
my lord, as per the FIR which was lodged by the All Idu Mushmi Student Union at Rowing Lower Dibang Valley, itself speaks that the earlier incident was
Speaking is something different, but the offense which you have, it's a different thing, no? You have committed in two different places.
my lord, as per the allegation, first allegation, which was instituted against me by the All Idu Mushmi Student Union, that I am poaching the Bengal tiger at Anni area.
Anini.
And thereafter, I return with all the articles that dead body and all the parts of the Bengal tiger to sold out in the Assam area.
Yes.
And in the similar incident, after, as per the allegation, after poaching the Bengal tiger, I came to sold out his articles within the area of Assam. Thereafter, Assam police officials and forest officials intercepted the vehicle and recovered that articles of that animal owner. Page number 24 is the first FIR. 24. That was lodged by all Idu Mismi Student Union,
24.
which was in question before this honorable court.
24.
24. Page number 24.
Yes.
In the subject itself, they narrated the entire story.
Hmm?
In the subject itself,
Hmm.
the complainant who lodged the FIR narrated the entire story
Hmm.
of the Assam, which was happened in the Assam.
Hmm.
And thereafter, my lord,
FIR against Mapi Kam Tega, a permanent resident of Shakunaga Mandir district. Yes. Then
thereafter, my lord, see the page number 48. Kindly see the page number 48.
48.
48, my lord. That was preliminary offense report and forwarding of accused against offense, which was,
This is second FIR.
this is second.
Huh?
This is second. No, this is first honor. This is first, and second one is all Idu Mismi student.
This is page
48.
24. Page 48, first FIR.
First FIR.
Hmm.
In this FIR, the brief details of the offense was written in the last para, my lord, last para.
Hmm.
Last para of page number 48. My lord,
Yes.
find
Hmm.
on 24 to 2023, the staff of Sadia Range Office, along with a team of Wildlife Crime Control Bureau, headed by Sri so-and-so, 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 caught one accused, MD Zakir Hussain. Address has been given, red-handed while trading articles of Royal Bengal Tiger. Unfortunately, one more accused who was along with the accused flee. That was another this present accused.
What is the stage now?
Now, this case has been charge sheeted and under trial.
In the second-
First FIR.
First FIR.
First FIR.
Okay.
And it was tried in the court of Honorable Additional Session Judge, FTC 2, Tinsukia,
Hmm.
against the accused persons.
Hmm.
Now, the question is on the second FIR that was lodged by the All Idu Mismi Student Union.
Hmm.
Now,
What
whether
is the stage of it? What about that?
this was stayed by this Honorable Court.
Hmm?
This was stayed by this Honorable Court on the first admission
So
hearing.
no proceedings.
No proceeding in this case. My humble prayer before this Honorable Court, that this FIR may be amalgamated with that case, or it may be quashed. Now, you know, one law point is here in this case. All in the Mismi Student Union cannot file any FIR regarding the wildlife offences as per section 55 of the Wildlife Act. Because Wildlife Act is very much clear. Page number 14 of my petition.
Hmm.
The Honorable Court may find for the according to section 55 of Wildlife Protection Act 1972, the following persons can file a complaint under this act: Director of Wildlife Preservation or any other officer authorized on this behalf by the central government, Second, member secretary, Central Zoo Authority in matter of violation of chapter 4A, member
You have been imposed cost of rupees 5,000 also. During
yes,
the
yes,
proceedings.
I have deposited.
Why?
Because not taking steps upon the respondents.
After obtaining interim order.
Yes,
Huh?
sir. Yes.
Why did you do so? Who is appearing for respondent number 2 and 3? Nobody.
Nobody, lordship, nobody till now. The service has completed.
Service is complete.
It appears to be out of same incident.
Lordship. Lordship, here, lordship, that's why, lordship, on last occasion, the honorable court has stayed, lordship. And moreover, lordship, here, one more, lordship, complaint is also there, lordship, before the magistrate.
But is there any,
As per the rule, lordship, FI cannot be lodged, but
is
complaint,
there any problem regarding the jurisdiction?
jurisdiction, lordship, there is no issue, lordship, because, lordship, here, lordship, they have.
Regarding jurisdiction,
Yes,
there is
sir.
no issue, my lord.
So are you admitting it's cannot be second FIR?
Lordship, lordship, here, lordship, the complaint is there, lordship, that's already there, lordship, before the magistrate, lordship. When lordship, what, at page 41, lordship.
Hmm.
Yeah, lordship, before the honorable sub-divisional judicial magistrate, lordship, the complaint lodged by one, lordship, this range forest officer. Otherwise, lordship, on two private parties, if they interested, then they can be participate, then next step may be for the hearing, lordship. So that, lordship.
No, once the service is completed, if they are not appearing, what can we do? Why don't you cooperate with the police in the investigation? You are absconding and filing this petition.
No, no, my lord. Case number 63. Page number 63, my lord found. I have filed one bail application before the Honorable Court of Sessions as
That's
Teju.
been rejected.
That was rejected only. Thereafter, we came before this Honorable Court under section 482. Because this complainant who has lodged this FIR is not entitled to file any FIR as per the section 55 of the Wildlife Act, my lord. Because as per the Wildlife Act, a private individual cannot file any FIR regarding the offences of Wildlife Act. Section 55 clearly stated as per the Your Honor, I submitted before this.
First FIR according to is correct.
Yeah, correct. First FIR is correct because that was lodged by the Forest Range Officer, Sadia, forest officials. But the second FIR, which was lodged by all Idu Missimi Student Union, they cannot file any FIR in this regard. Section 55 of Wildlife Protection Act.
55.
55. They are not entitled, even though they filed this FIR. And in the place of FIR, a complaint should be required to be Your Honor filed. A complaint should be registered before the magistrate regarding the wildlife offences.
Lordship, without taking much time, Lordship, I have prayed, Lordship, it may be listed for after, Lordship, 1 week, Lordship, because I have not go through the petition properly, because earlier occasion I was never appeared, Lordship. So,
It
Yes.
is, it is clear from the mandate of the law, my lord. It is clear from the mandate of the law, my lord, that every person is not eligible for filing a complaint or FIR against the offences which comes under the purview of Wildlife Act.
Where is the rejection, bail rejection order?
63,
60,
page number 63, my lord.
60?
3, annexure 4.
Sixty-two.
Yes, my lord.
Page 63 lordship, next up for.
Annexure 4.
Yes.
So I pray before this honorable board to pass the FIR, my lord.
Any law? Any
I-
case laws?
I submitted all these things before this honorable court, my lord.
Huh?
I submitted all these things before this honorable court, Your Honor.
Where it is?
As per section 55, they are not entitled to file this FIR.
No, I'm asking any case law.
Case law, I have not submitted any case law, my lord, today.
Well, I have to do your homework.
No, my lord. This is apparent from the FIR itself, my lord. The mandate
Your
of the,
plan is there cannot be two FIR,
yes,
second FIR for the
Second.
same offense or
Same.
the incident.
yes,
There's so many judgments of the Supreme Court. Number two, as per the Wildlife Protection Act, as per section 55, the student union or for any other person cannot make any complaint other than the officers or the persons uh, uh, provided in the section 55.
yes, my lord.
These are two grounds.
Yes.
So far the first grounds are concerned, there is so many judgments of the Honorable Supreme Court. This is why I'm asking.
In the continuance of the same offense, my lord, this FIR was lodged. In the continuance, first,
I'm asking case laws, what is the judgment of the Supreme Court, decision of the Supreme Court?
pardon, my lord, today I am not bringing any judgment in this regard.
Yes, what do you say?
Then lordship, next date may be fixed or short
What
date,
next
lordship.
date? I have heard him. You make your submission.
Lordship, as per the lordship, here lordship, they
We
against the
spend
first,
around 10 minutes or 15 minutes.
against the first FIR lordship, the bail has already been rejected lordship. Then after the rejection of bail, they have come before the court for the quashing.
It's okay.
Lordship.
Now, the issue is what he has said is
The two
that
FIR is not.
there are
lordship.
two FIRs. First one is genuinely filed, I mean, appropriately filed by the, it was to be filed by the, as per the Act, provisions of the law, it is filed, it's pending.
Mm.
The student union is not, they are not, nobody to make a complaint. It is the concerned officer or the officials
Lordship.
provided in the Act of 1955 that they can. That effort,
Lordship.
since the same incident, same offense, which is pending, you cannot have a second FIR. You can file a second FIR. Therefore, second FIR filed by this pending case, in any case, is not, it's not maintainable. It cannot be taken cognizance. I think he's right.
Lordship, that's why lordship, it was already state lordship.
So I'll,
Pass the order lordship.
I'll pass the order
Lordship.
after doing homework, which you are ought to have done,
Lordship,
both of you.
Obliged, Your Honor.
lordship, as per the rule lordship.
Let us see when
Lordship.
I can.
As
expose
per
that.
the, that's
First,
what
I'll go
lordship,
through the
yes, lordship.
document.
Lordship, as per the rule, lordship, this FIR lordship cannot be lodged any other person apart from the lordship,
Yeah.
which is included lordship. That's why lordship, the by rainforest officer, they have made a complaint before the lordship, JMFC lordship. Against
Where
the,
it is.
Here was page 41, Lordship, I have shown. Lordship.
41.
Yes, Lordship. There's a complaint under section 55 of wildlife.
Division, complaint. Has it been, what, is it, the case registered?
Lordship, this
I
is.
mean, the FIR,
That was lodged by the Sadia range officers, forest range officers. That complaint was lodged by the Sadia.
this is, after this Anini PS case, 4 of 23 has been registered.
No, before that, Lordship.
Before
No,
that.
Before that.
Before that, that is what he's saying. That is
Lordship.
with regard to first FIR.
Lordship. That's why, Lordship, if
What he's saying that after the registration or investigation, whatever of the first FIR, the students' union
again they have no. That's why,
Violent-
Lordship.
FIR or filed a complaint, which they are not entitled
entitled.
to under the provision of section 55.
Lordship.
So this is which it cannot be maintained.
Lordship, that's why, Lordship, it cannot be, Lordship. That's why I'm submitting, Lordship, which already is, Lordship, registered. So this is they have,
So we'll allow your petition directing to club with the first FIR.
Lordship, they
That will
can.
be better.
That will be better. Obliged.
Because investigation has to be, it is shown that you, the carcasses have been found in your car.
Yes.
Though you try to evade the thing, but then it would be better amalgamated or clubbed with that.
Yes, yes, madam.
Yes.
Yes, madam.
And the investigation has to also be continued.
Yes, madam.
Investigation we cannot stop. If there is nothing against you, you'll be free. But let there be investigation by amalgamation or clubbing both the complaints. All right,
Obliged.
Obliged.
disposed, huh? One 183 will be taken up first.
Yes, my lord.
180.
7 will be the application.
You can. It's yours. Voluminous.
It's not voluminous. In fact, the annexure is voluminous. Because the copy which is served on us, we have annexed it. There was no other alternative. Because copy has to be seen and looked into as to what was served on us.
You have annexed all that.
Yes, entire thing we have annexed, my lord, because otherwise it won't be possible to make submission. I have to show the discrepancies, which in my humble submission would be, they would be quite substantial.
Take up 183,
Yes,
right?
183 first.
Yes.
Order 7 Rule 11 application. No, not here. To begin with, I place section 86 may kindly be seen of Representation of People's Act, 1951.
Just wait.
Section 86.
Yes,
I read below.
yes.
Trial of election petitions, subsection 1. The High Court shall dismiss an election petition which does not comply with the provisions of section 81 or section 82 or section 117. So 3 sections have been pointed out: 81, 82 and 117. If election petition doesn't comply with these provisions, the High Court shall dismiss an election petition. Now, my lord, straight away I'll take your lordship to section 81. That will be my ground number 1. Now, section 81, presentation of petition. An election petition calling in question any election may be presented on one or more of the grounds is specified in subsection 1 of section 100 and section 101 to the High Court by any candidate at such election or any elector within 45 days, but not earlier than the date of election of the returned candidate, or if there are more than one returned candidate at the election and the dates of their election are different, the latter of those 2 dates. Now, explanation. In this subsection, the elector means a person who was entitled to vote at the election to which the election petition relates, whether he has voted at such election or not. Subsection 2 has been omitted by an amendment. Now, subsection 3 is important. Section 81, subsection 3. Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. Now, my lord, there are 3 fundamental aspects. First of all, election petition shall be presented within 45 days from the date of election. First. Second, every election petition shall be accompanied, that is subsection 3, by as many copies thereof as there are respondents. In this case, there was 1 respondent. So, election petition within 45 days has to be presented with a copy of the respondent also. If you do not present it with the copy of the respondent before the registry, it would be barred by time. It would not be an election petition. Election petition can't be complete if the copy is not there along with it. As many copies thereof as there are respondents mentioned in the petition. That is number 2. So, number 3 is every such copy, not only the election petition, but also the copy meant for the respondent, shall be attested by the petitioner under his own signature to be a true copy of the petition. These are the 3 fundamental aspects of section 81. Now, my lord, I ask myself as to whether they have complied with it. 45 days I will deal with, but prima facie, this is the copy lordship may see in action. It starts from page 13. Where do we find attestation by the petitioner? At least I have not got it.
Page 13.
Yes, page 13 onwards. Even the letter 7 is written by my junior for our convenience. It is the copy as it is, absolutely blank. Absolutely blank.
All.
Yes, and
Not,
that's it.
not even a single copy, single page.
I don't find anything. I don't find anything. Let us see the. Only the verification, my lord, will find. Verification, page 83, bottom.
83.
83, bottom. Tadar Nanku is mentioned, is written there. I presume, I can presume only, I don't know. Affidavit, Tadar Nanku. 83, 84, 85, Tadar Nangko.
Okay.
Form 25, Tadar Nangko. Page 87. So page 83 to page 87, my lord will find handwritten Tadar Nangko in each of the page, 83 to 87.
Up to 87.
Yes.
Okay.
Whether from there the respondent has to presume that it is the true copy of the election petition, whether it is compliance of section 81 subsection 3 second part. That is the question for my lord's consideration. Because section 81 subsection 3 part 2 says clearly every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. Signature at the bottom from 83 to 87. I don't know whose signature and whose handwritten noting is this. Mere mention of Tadar Nangko, whether that is compliance of section 81 subsection 3 part 2.
Even if that he has put his signature, unless it is attested.
Yes.
It is.
How do we know what is this? The sole purpose behind it is the respondent has to know this is the genuine petition, that he has been served with the genuine petition. So, my lord, I clarify. Here is a case wherein practically the respondent was left with no choice but to go for a certified copy. After being served with this, we had no choice. And they never tried to correct themselves, even when Order 711 application was filed. No, my lord, this is in respect of section 81 subsection 3 part 2. Now there are few dates which lordship may kindly take note of. That is in respect of 45 days, section 81 subsection 1. The first date is 2nd June 2024, election was completed. On 2nd June 2024, respondent was declared elected and election got completed.
0207. 0207.
06 2024.
June, yes.
0206 June. 45 days gets completed on 17th July 24. 17/7/24. 45 days are completed.
17/7/2024. Yes.
We find from the records that on 16th July 24 election petition was filed.
Election petition was filed?
On 16th July 2024.
16 July. Yes.
On 31st July 24 election petition came on board and my lord directed
Yes.
taking of steps with registered post within 2 days. So that is on 31st July. Taking of steps within 2 days. Now, my lord, 45 days are completed on 17 July.
Yes.
As per the mandate of the law, as on 17 July 2024, election petition ought to have been filed along with the copy for the respondent. And here in this case, lordship may also take note of the procedure is there under chapter 8, capital A of the High Court rules. It complements section 81 only. It is 81 only, practically. Chapter 8A of the High Court rules. Lordship may kindly see Rule 1A. Chapter 8, Rule 1A only supplements what is there mandated by Section 81 of the RP Act.
Page number?
Page 88.
88. Yes. 8A.
Rule 1, my lord, I read. An election petition under Section 80, capital A of Representation of People's Act may be presented, duly verified, in the form prescribed under Section 82 and 83 of the said Act before the stamp reporter of this court with a court fee of ₹6 affixed thereon within 45 days Section 81 subsection 1 says so. Within 45 days from the date of election of the returned candidate, or if there are more than one returned candidate at the election and the dates of their election are different, the latter of those two dates, every such petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, together with one extra copy. So practically, they were required to file 2 copies. One for respondent and one extra copy as per the High Court rules. All the copies being fully attested by the petitioner under his own signature to be a true copy of the petition, and as many envelopes as there are respondents bearing, it is not hearing, bearing requisite postage stamp to enable service to be effected by registered post with acknowledgement due. My lord, this supplements section 81 subsection 1 of the RP Act. Now, my lord, my submission is election petition was not filed along with the extra copy. 2 extra copies ought to have been there. There were no envelopes, there were no stamp. All this ought to have been with the registry. My esteemed junior colleague looked into the record. This is my information. I have not seen it personally. He says there is nothing to indicate from the notings, files, etc. in the records, right, that 2 extra copies were there along with the election petition with envelope and stamps, etc. It seems, again, it seems, I don't know, registry would know better, only on 31st July 2024, after expiry of 45 days, when petition came on board and my lord directed steps to be taken, then possibly they went to the registry along with the extra copy.
Okay.
So that is after the expiry of 45 days. So my 2 submissions are, number 1, violation of section 81 subsection 1, because election petition was not accompanied by 2 extra copies along with envelope and postage stamps for taking of service for the respondents. And 81 subsection 3 part 2, the copy which is served to the respondent is not a truly attested copy. There is no attestation, no signature, nothing to indicate. Now, my lord, in support of this proposition, I place one judgment. 1974, 4 SEC.
Yes.
1974, 4 SEC, page 237. That is Satyanarayan versus Dujaram.
Satyanarayan
versus Dujaram is constitution bench, 3 judges.
Satyanarayan
versus Dujaram, DHUJA. Dujaram.
Satyanarayan.
The majority judgment, majority opinion is delivered by Justice Goswami. The important paragraphs I will read. I begin from para 1. This appeal under section 116 capital A of the Representation of the People Act 1951 is directed against the judgment and order passed by the High Court of Punjab and Haryana in election petition number such and such, dismissing it on the preliminary ground that the appellant had failed to comply with the mandatory requirement of section 81 subsection 3 of the Act, inasmuch as the requisite number of spare copies of the petition for the respondents were not filed along with the petition in the High Court. It was further held by the High Court that the said defect could not be cured subsequently, even within the period of limitation prescribed for filing the election petition. The High Court further held that the spare copies were actually filed beyond the period of limitation. Now, para 2, the facts may be briefly stated. In the general election to the Haryana Legislative Assembly held on March 11, 1972, the appellant and the 4 respondents were the contesting candidates for the Safid-Down Assembly constituency number 30. 2 candidates having already withdrawn from the contest. The counting of votes took place on March 12, 72, and on the following day, the counting disclosed that the first respondent obtained 19,570 votes as against 19,462 votes secured by the appellant. The first respondent was therefore declared elected on March 13, 72. The appellant filed an election petition in the High Court challenging the election of the first respondent on several grounds of corrupt practice within the meaning of section 123 of the Act. It is not necessary for the purpose of this case even to detail these. The election petition was presented by such and such advocate in charge to the deputy registrar such and such on April such and such, such and such. It is admitted that the application was filed on April 18, 1972 without the requisite spare copies and was therefore incomplete on the date of presentation. No schedules were also filed along with the petition, but that point is not pressed before us by the respondent counsel. It is also admitted that the limitation for filing the election petition was up to April 27, 1972. According to the appellant, the spare copies were filed with the Superintendent of Election Branch in the afternoon on April 24, 1972, well within the period of limitation. It may be necessary to briefly note the sequence of events for the purpose of appreciating the controversy raised between the parties. As noted earlier, the election petition was presented personally by such and such without the spare copies on such and such, and the deputy registrar had ordered it to be put up on such and such for scrutiny according to the rules of the High Court. When the petition came up for scrutiny before the deputy registrar on such and such, Mr. Such appeared and requested for time to remove the defects pointed out by the office. It may be appropriate to extract that particular order. So orders extracted, such and such, then the Lordship will find. Lordship may turn to straight away para 7 now. Para 7. Basic facts Lordship has taken note of. The basic thrust of the argument was extra copies were not there within the period of limitation, 45 days. Para 7. We will therefore have to decide the first submission of the learned counsel for the appellant on the basis that the spare copies were not filed within the period of limitation. The short question is, para 8. The short question is whether section 81 subsection 3 of the Act is mandatory, and if so, whether non-compliance with the same will visit the election petitioner with the penalty of dismissal of his petition under section 86(1) of the Act. This question was mooted in Jagat Kishore Prasad Narayan Singh versus Rajendra Kumar Poddar, but the court did not find it necessary to decide the same. Now, para 10, Lordship thereafter. Para 10. Now, there are two parts in section 81 subsection 3. The first part provides, quote, that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, unquote. The second part relates to the manner in which, quote, such copy shall be attested by the petitioner under his own signature to be a true copy of the petition, unquote. We are concerned only with the first part in this appeal. My lord, my submission is in respect of both the parts. 81 subsection 1, 81 subsection 3, second part. Now, para 13 and para 14, the conclusions of the court. Para 13 and para 14. Para 13, keeping in the forefront the proper functioning of democracy, the principal object of the Act is purity of elections. When therefore an election of a returned candidate is challenged under Act, expeditious trial of election dispute is sought to be enforced by the legislature, making all safeguards against delay. Trial has to be necessarily expedited to rid the candidate as well as the constituency interested in the result of the election of any taint or suspicion of corrupt practices, which are again clearly enumerated in the Act. To take therefore another important object of the Act, viz. Expeditious disposal of election petition, by section 86B, the trial of election petition shall, so far as is practicable, consistently with the interest of justice in respect of the trial, be continued from day to day until its conclusion, unless the High Court finds the adjournment of the trial beyond the following day to be necessary for reasons to be recorded. Again, under section 86 subsection 7, every election petition shall be tried as expeditiously as possible, and endeavor shall be made to conclude the trial within 6 months from the date on which election petition is presented to the High Court for trial. Further, section 87 subsection 1 introduces the Civil Procedure Code only subject to the provision of the Act and of any rules made thereunder. Section 87(2) makes a deeming provision for application of the Evidence Act only subject to the Act. Therefore, there is no scope for free play in the application of the provisions of those two acts. the very object of expeditious trial will be defeated. Yes, from here onwards, the vital part begins. The very object of expeditious trial will be defeated if the presentation of the election petition should be treated casually and lightly, permitting all kinds of devices to delay the ultimate trial. The purpose of enclosing the copies of the election petition for all the respondents is to enable quick dispatch of the notice with the contents of the allegations for service on the respondent or respondents, so that there is no delay in the trial at this very initial stage when the election petition is presented. If therefore any halt or arrest in progress of the case, the object of the act will be completely frustrated. We are therefore clearly of opinion that the first part of section 81(3), with which we are mainly concerned in this appeal, is preemptory provision, and total non-compliance with the same will entail dismissal of the election petition under section 86 of the Act. We are therefore not required to consider the second submission of the learned counsel for the appellant with regard to substantial compliance made on the basis of the provisions of section 81 subsection 3 being directory. We may only add here that in the absence of any provision under the Act or the rules made thereunder, the High Court rules cannot confer upon the registrar or the deputy registrar any power to permit correction or removal of defects in an election petition presented in the High Court beyond the period of limitation provided under the Act. In this case, not after the expiry of 40 days, they made the corrections before the registrar and supplied the copies. It may be noted that section 169 of the Act provides that the central government is the authority to make rules after consulting the Election Commission, and in subsection 3 thereof, the rules have to be laid before each House of Parliament in the manner provided therein. The only reference to the High Court rules is found in section 117 of the Act. At any rate, we do not feel called upon to pass on the High Court rules referred to in the judgment of the High Court in this case, such and such. In the result, we find no reason to interfere with the decision, and the High Court dismissing the petition, so may not dismissal was upheld. Practically, Lordship will find in paragraph 7 and paragraph, no, not 7 and 8. In this very case, my lord, the extra copies were not supplied within the period of 45 days before the concerned authority of the High Court. Over here also, my lord, we do not find any evidence. Thereafter, my lord, so far as 81(3) is concerned, I'll place one authority, 2005 to, 1980, no, just 1984, 3 SEC, 339.
1984.
3 SEC. page 339. Paragraph 8, 10, and 15. Para 8 at page 343. This being the position, para 8, it is manifest that the appellant did not receive the correct copies as contemplated by section 81(3) of the Act. The respondent has also not been able to prove that the copies served on the appellant were out of 10 corrected copies which were signed and filed. Here, not more than lots of respondents were there. So, not many copies were filed along with the election petition. Some were corrected, some were not even corrected. So therefore, it seems that a copy which was not a corrected copy was served on the respondent. The respondent has also not been able to prove that the copies served on the appellant where out of the 10 corrected copies which she had signed and filed, it appears that in view of a large number of copies of the petition having been filed, there was an utter confusion as to which one was correct and which was not. It is obvious that if an election petitioner files a number of copies, some of which may be correct and some may be incorrect, it is his duty to see that the copy served on the respondent is the correct one. A perusal of section 81(3) and 86 of the Act gives the impression that they do not contemplate filing of incorrect copies at all. And if an election petitioner disregards the mandate contained in section 81(3) by filing incorrect copies, he takes the risk of the petition being dismissed in limine under section 86. It is no part of the duty of the respondent to wade through the entire record in order to find out which is the correct copy. If out of the copies filed, the respondent's copy is found to be an incorrect one, it amounts to non-compliance of the provision of section 81(3), which is sufficient to entail a dismissal of the election petition at the behest. Now, my lord, pausing here, I submit, assuming for a moment, my lord, assuming for a moment without admitting, because our entire case is extra copies were not there along with the election petition on the date when the election petition was filed. It is only when my lord issued the notice after 45 days they went there. Now, assuming for a moment extra copies indeed were there, assume also those copies indeed were absolutely correct copies and there was no defect in those copies. And that by registered post, steps were taken with the help of that very copy only, which we never received, of course, they were received unserved. Then in that case, my lord, once the order for dusty service was issued, since by that time the copy had returned unserved, it is that very copy which ought to have been served on the respondent. Instead of, some other copy, which they carried in envelope and which obviously I have annexed here, which we received. It was their duty to do that. We do not know what exactly they did, but the fact of the matter is, this is not a correct. Now, para 10. In these circumstances, therefore, in the instant case, there was absolutely no justification for the learned judge to have invoked the doctrine of benefit of doubt. The learned judge invoked the doctrine of benefit of doubt at the level of the High Court. The Supreme Court did not accept that. We are satisfied that it has not been proved by the respondent that she filed correct copies of the election petition, or for that matter, the appellant got the correct copy and not the incorrect one, in the face of the clear and categorical assertion by him that he did not receive the correct copy. So, the condition of respondent was accepted. For these reasons, therefore, the appeal is allowed and the election petition filed by respondent is dismissed under section 86 of the Act. There will be no order as to cost. So, this is my first ground. Namely, there is total non-compliance of section 81, subsection 1 of the Representation of People Act. The presentation is an incorrect presentation. The extra copies were not there along with the election petition within the period of 45 days, and the extra copies indeed were filed after the 45 days because records don't say so. Assuming the copy was there, the stamps and the envelopes are not there. Even if you bring envelope and the stamps after a period of 45 days, that is no compliance. And second part,
the extra copy has to be as good as that of the
similar.
petition of the
And attestation is necessary.
attestation, stamp, envelope,
everything. Along with the stamp, so that the moment notice is issued.
Only one petition was filed on 16/7 within the time.
This is what
but there's no extra copy at all.
This is because records don't say so. There is nothing to indicate.
No, according to you.
Yes, this is what I have been told.
Yes.
Because there is no noting, nothing that election petition. Because once election petition is presented, I would see a noting of the authority of the
No,
court.
whether you have seen it or not, you must be believing him,
This is
and
what
you
was
must
told.
be you are asserting so.
No, I have not, because I believe on instructions.
Yeah.
So I have been instructed like this. He has verified, he has checked, and he doesn't find it. The second leg of this argument is in respect of section 81, 81 subsection 3. There is no attestation of the petitioner. 83 to 87 pages at the bottom, name is written in running, is a running signature, but that is no attestation in the eye of law. It is not a compliance of section 81 subsection. Now, my lord,
Yes.
the second ground I'm urging.
Yes.
For second ground, my lord, first I will take my lord to section 83 subsection 1 proviso.
Eighty-three.
83. 83 deals with the contents of election petition.
Yes.
My focus and my thrust would be on subsection 1 proviso. I'll just, for the benefit of the lordship, read the entire thing. 83 contents of petition. In an election petition, A shall contain a concise statement of material facts on which the petitioner relies. B shall set forth full particulars of any corrupt practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such corrupt practice and the date and place of the commission of each such practice, such and such. C shall be signed by the petitioner and verified in the manner laid down in the Code of Civil Procedure. Then the proviso comes, my lord, which is important. Provided that where the petitioner alleges any corrupt practice, the petition shall also be accompanied by an affidavit in the prescribed form in support of the allegation of such corrupt practice and the particulars thereof. This is the proviso. Now, my lord, this is important because the allegation is of corrupt practice and the prescribed form is the form 25. Petition shall also be accompanied by an affidavit in the prescribed form in support of the allegation of such corrupt practice and the particulars thereof. So, form 25. Now, form 25, lordship will find here, there is form 25 and there is some kind of a signature at the bottom of the form 25. Page 87, lordship may kindly see, because 83 to 87, these 4 pages, there is a signature of somebody. One may say that it is Kadar Nanku. 87, Kadar Nanku, signature of deponent. Now, lordship would find before me, magistrate of the first class, everything is blank. Everything is blank.
87.
Is blank. Now, whether, my lord, I ask myself as to whether this is compliance of section 83, subsection 1 proviso. My submission is, this is not a compliance. Because the form 25 is not notarized. Form 25 affidavit is not notarized. I place the case law now, my lord, on the subject. The first authority I place is 1996 5 SCC 5 SCC. Let me have it. (96) 5 SCC 181.
Dr. Chipra.
Yes.
Chipra.
Paragraph 10 and paragraph 11. My lord, here all the 3 judges delivered separate opinion. So first I will show, my lord, the relevant paragraph of Justice Ramaswamy. Para 10 and para 11.
Yes.
Para 10, para 11. Para 10. Straight away, my lord, I'll take your lordship to at page 189. Page 189, Placitum F, lordship may kindly see. 4 lines from placetum F, just 3 lines above placetum G. In none of the cases, whether my lord has got it. Page 189, just 4 lines from placetum G. In none of the cases, the present question had arisen. Earlier cases have been referred to, and question code dealing with this Form 25 affidavit. In all the cases, though the affidavit or the election petition contained allegations of corrupt practices and true copies were served, the omission in the copies were not of material facts, which become an integral part of the election petition or of the pleadings. Therefore, this court had not insisted upon the strict standard of the scrutiny as required under section 86. Then comes the law, court refers to an authority at para 11, at page 190.
Yes.
The present question had directly arisen in Purushottam versus returning officer. The present question had directly arisen. In that case, the copy contained omission of vital nature, with the attestation by the prescribed authority. The High Court had held that the concept of substantial compliance cannot be extended to overlook serious or vital mistakes which shed the character of a true copy, so that the copy furnished to the returned candidate cannot be said to be a true copy. We approve of the above view. Verification by a notary, now this is important, verification by a notary or any other prescribed authority is a vital act which assures that the election petitioner had affirmed before the notary, etc., that the statement contained imputation of corrupt practices was duly and solemnly verified to be correct statement to the best of his knowledge or information as specified in the election petition, and the affidavit filed in support thereof, that reinforces the assertion. Thus, affirmation before the prescribed authority in the affidavit and the supply its true copy, important, and the supply of its true copy should also contain such affirmation, so that the returned candidate would not be misled in his understanding that imputation of corrupt practices was solemnly affirmed or duly verified before the prescribed authority. So, below, the moment I get a copy, if I see Form 25, the moment I will see the seal signature of magistrate, then I will be convinced, yes, he is serious about it. If that is not there, I'll be misled. I would say this is not attested. I'm not supposed to rush to the registry, check in the records of your lordship's file and find out whether it is verified or not. It was mandatory for them to supply it. For that purpose, Form 25 mandates verification before the prescribed authority. The object appears to be that the returned candidate is not misled that it was not duly verified. The concept of substantial compliance of filing the original with the election petition and the omission thereof in the copy supplied to the returned candidate as true copy cannot be said to be a curable irregularity. It is not a curable irregularity according to Supreme Court. Allegations of corrupt practices are very serious imputations, which if proved would entail civil consequences of declaring that he became disqualified for election for a maximum period of 6 years under Section 8 capital A. Apart from conviction under Section 136(2), therefore, compliance of the statutory requirement is an integral part of election petition, and true copies applied to the returned candidate should, as a sine qua non, contain the due verification and attestation by the prescribed authority and certified copy to be true copy by the election petitioner in his or her own signature. The principle of substantial compliance cannot be accepted in the fact situation. Then we got Justice Bharucha. Justice Bharucha, my lord, the relevant paragraph is paragraph 17. Justice Bharucha explained as to why this is necessary. It is supplementary judgment, para 17 at page 191. The question that must be posed, as indicated by this court's previous decision, is: does the document purporting to be a true copy of the election petition misled in a material particular? The quote-unquote true copy of the election petition furnished by the appellant to the respondent did not show that the appellant's affidavit supporting his allegations of corrupt practice had been duly sworn or affirmed. Where corrupt practice is alleged, the election petitioner must support the allegation by making an affidavit in the format prescribed. And affidavit must be sworn or affirmed in the manner required by law, or it is not an affidavit. The document purporting to be a true copy, this is important, the document purporting to be a true copy of the election petition furnished by the appellant to the respondent gave the impression that the appellant's affidavit supporting his allegations of corrupt practice had not been sworn or affirmed and was therefore no affidavit at all. It misled in a material particular, and its supply was, as the High Court held, fatal to the election petition. Then, my lord, there are the same thing has been again explained in para 22, again para 23. Relevant paragraphs I am giving, my lord, to save time. Justice Paripurnan, my lord, para 22 and para 23. In para 23, the paragraph 50 has been quoted from Purushottam case. So, Lordship may kindly take note of that also. Para 22 and 23. Now, my lord, the same principle was reiterated in Harcharan Singh Josh versus Harkishan. The same principle. 1997, 10 SCC 294. And now I will give relevant paragraph. My lord, I will not read the same thing. My lord, the same principle.
Yes.
1997, 10 SCC 294. Para 2. Harcharan Singh Josh versus Harikishan.
Para 2.
Para 2. Same principle. Reiterated. Then, my lord, the third case came. There was a slight deviation by the Supreme Court because, my lord, I made it very clear to your lordship. I will place everything. There was a deviation. In Anil Deshmukh versus Omkar Wagh, 1999, 2 SCC 205. 1999, 2 SCC 205. This I place because there was slight deviation. The rigors were slightly loosened by the Supreme Court. And then there is a further development. I'll place that also for my lord's consideration. Then my lord will decide. 205.
This is 91.
Yes.
99.
Lordship, your previous year book, Lordship,
Here. 99 is there. 1999.
1999, volume 2 SCC. Volume 2 SCC. Page 205.
Why don't you have this displayed for? Yes.
I read from paragraph 3. Para 3. At page 207. When the copies of the petition, documents and the affidavit were served on the respondents, the copy of the affidavit did not bear. This is not relevant. The copy of the affidavit did not bear the endorsement of attestation found on the original or the seal or stamp of the attesting officer. In this case, it ought to have been judicial magistrate. The appellant signed below the rubber stamp endorsement attested as true copy. Here will not be find only a running signature, nothing else. But the absence of the notarial endorsement, it was a true copy of the original as it was a Xerox copy. The first respondent and the 10th respondent raised objections that the election petition should be dismissed in limine as the provision of section 83(1) of the Act were not complied with. Besides the contention that the copies of the affidavit served on them were not true copies. The 10th respondent contended that a true copy of the petition was not supplied to him as required by section 81(3). The first respondent filed a separate application for dismissing the election petition for non-compliance with section 81(3) of the Act. Issue 8 and 9, based on the said objection, were as follows. Issues discussed that para 5. The two issues were treated as preliminary issues because the two issues were whether, issue 8, whether the affidavit filed by the petitioner under the provision of proviso to section 83(1) of the Representation of the People Act 1951, read with rule 94 capital A of the Conduct of Election Rule 61, is not in conformity with the provisions, and if yes, what is its effect? Issue 9, whether the true copy of the petition is properly served on the respondent in compliance with the rules. Para 5. The two issues were treated as preliminary issues, and the High Court heard arguments on the same before the commencement of the trial. The court found against the contention that the true copy of the petition was not supplied. But the objection that the copy of the affidavit supplied was not a true copy, inasmuch as it did not contain the endorsement of attestation, was upheld. So, my Lord, High Court upheld that. The High Court held that the defect was fatal to the election petition and dismissed the same for non-compliance with section 83 subsection 1, read with section 81 of the Act. For coming to the said conclusion, the High Court relied on a previous judgment of that court in Purushottam versus Returning Officer, which was approved by this court in Shipra Doctor versus Shantilal Khoiwal, which Lordship has already seen. Then comes, my Lord, I'll straight away come to para 8. Section 86(1) has been dealt with. Section 86(1) of the Act provides that the High Court shall dismiss an election petition which doesn't comply with the provisions of Section 81, 82, or 117. Section 81 deals with the presentation of petition. It is not the case of the respondent that there is any defect in the presentation of election petition as prescribed such and such. Discussion goes on, my lords. Finally, let us turn to relevant. Para 14, Purushottam discussed. Para 14, I will skip. Para 15, Dr. Shipra versus Shantilal principal discussed. Again, I will skip. The same thing. Then comes para 16. 16 and 17 are important, my lord, so far as this case is concerned. This shows the development and the little deviation by the Supreme Court.
Yes.
Para 16 at page 212. The scope of ruling in Dr. Shipra case came up for consideration in T.M. Jacob versus C. Paulos before a bench of 3 judges. The bench referred the matter to a larger bench. I will place the judgment of larger bench also with the following observation, quote, having heard such and such, we are not too sure that the principle indicated in the said decision can apply to the facts of the present case, but certain wide observations in the opinion of Justice Paripurnan and Justice K. Ramaswamy may support the appellant's contentions. In our opinion, the matter would therefore require reconsideration by a larger bench to decide whether even in a case like the present one, the decision in Dr. Shipra versus Shantilal Khoiwal will apply. Para 17. It is to be noticed that the reference is only with regard to the applicability of Dr. Shipra in cases like the one which arose before the said bench. In the light of the rulings of the Constitution bench referred to earlier, we have our own reservations on the correctness of the view expressed in Dr. Shipra case. But it is unnecessary in the present case to dwell on the same. As pointed out earlier, Justice Ramaswamy has confined the ruling to the fact situation in that case. Insofar as the present case is concerned, we're not pausing here, I'll submit the fact situation in Dr. Shipra case is precisely the fact situation in the present case. So far as his Anil Deshmukh case is concerned, the fact situation was a little different. Here may not the same thing like Dr. Shipra. Absolutely, there is nothing, no way to find out if there is any attestation. Had the copy served on us been a photocopy of the election petition, there would have been at least a symbol of the attestation, etc. We could have made out. Even that is missing. But it is unnecessary in the present case to dwell on the same. As pointed out earlier, Justice Ramaswamy has confined the ruling to the fact situation in that case. Insofar as the present case is concerned, there is a distinguishing factor which makes the ruling in Dr. Shipra case inapplicable. We have already referred to the fact that even before arguments, now this is very important, my lord, we have already referred to the fact that even before arguments were heard on the preliminary objection by the High Court in this case, the true copies of the affidavits had been served on the first respondent and his counsel. In the facts and circumstances of this case, we have no doubt that there was sufficient compliance with the provision of Section 81(3), read with Section 83(1)(c) of the Act, even if it could be said that the copies served in the first instance of the first respondent were not in conformity with the provisions of the Act. Unfortunately, this aspect of the matter has been completely ignored by the High Court. Hence, the order of the High Court dismissing the election petition in limine is unsustainable. Now, I'm not pausing here. I submit in the present case, when I served the copy of Order 7 Rule 11 application on my esteemed colleagues, when the copy was served on them, the moment they read it, had they supplied us the true copy of the election petition, they would have fallen squarely, they would have been squarely covered by Anil Deshmukh principle. Here, my lord, the fact situation present is squarely covered by Dr. Shiprakis. This is my submission, and that is how I distinguish Anil Deshmukh. Now, my lord, I'll come to Pavlov. C. Pavlov's, that is the law of the land, T.M. Jacob versus C. Pavlov's, 1999, 4 SCC 274. (99)4 SCC 274. The two paragraphs are para 16 and para 17. Shipra case has been discussed. The observations of Justice Bharucha considered by the Supreme Court, including the Anil Deshmukh principle, both in para 16 and para 17. I read para 16 first. Para 16 at page 284. Thus, from the facts noted by Bharucha J, that is in Shipra case, it transpires that in Dr. Shipra case, the true copy of the election petition furnished to the respondent gave an impression that the election petitioner's affidavit supporting his allegations of corrupt practice had not been duly sworn and verified by the election petitioner before the notary. Gave an impression because the copy served did not contain that. Who also had not attested the same, thereby rendering that document as quote unquote no affidavit at all in the eye of the law. The defect found in the quote unquote true copy of the affidavit was thus not merely the absence of the name of the notary or his seal and stamp, but a complete absence of notarial endorsement, quote unquote, of the verification, as well as absence of an affirmation or oath by the election petitioner. It was in that context that the bench had found in Dr. Shipra case that the returned candidate would have got the impression on a perusal of the true copy of the affidavit that there was no duly sworn and verified affidavit filed in support of the allegations of corrupt practice by the election petitioner. It was precisely on account of this fatal defect that K. Ramaswamy Ji opined that the principle of substantial compliance cannot be accepted in the fact situation. And we're not pausing here. My submission is, my case is squarely covered by Dr. Shipra's situation and not Anil Deshmukh. Then para 17. In Anil Deshmukh versus Onkar and Walk, the appellant had filed an election petition for declaring the election of the first respondent, in that case as void and illegal, and for declaring him as duly elected. The petition contained allegations of corrupt practice against the first respondent. An affidavit had been filed along with the election petition as required by the proviso to section 83(1)(c) of the Act in support of the allegations of corrupt practice. The affidavit was duly affirmed by the election petitioner before the notary, who had also attested the same, and the notarial endorsement of attestation contained all the particulars required by law. However, when the copies of the election petition, along with various documents and the affidavit, were served on the first respondent, it was found that the copy of the affidavit did not bear the seal or stamp of the attesting officer below the notarial endorsement after the verification of the affidavit. The appellant had, however, signed the copy of the affidavit below a rubber stamp endorsement to the effect, quote unquote, attested as true copy. On account of the above omission, the first respondent and the 10th respondent therein contended before the High Court that the copies of the affidavit served on them were not true copies of the affidavit as required by section 81 subsection 3 of the Act. The issue was tried as a preliminary issue. The High Court found that the copy of the affidavit supplied to the first respondent was not a true copy, inasmuch as it did not contain the particulars of the notary below the endorsement made by the notary. The High Court, following its previous judgment in Purushottam versus Returning Officer, which had been approved by this court in Dr. Shipra case, held that the defect of omission of the particulars of the notary on the copy of the affidavit served on the answering respondent was fatal, and dismissed the election petition for non-compliance with section 81 subsection 3 of the Act. Now, my lord, para 21 and para 22. Para 21 at page 286. Reverting now to the facts of the present case, a perusal of the copy, the present case, that is the case before the court in TM Jacob, a perusal of the copy of the affidavit served on the appellant shows that the copy of the affidavit supplied to the appellant contained the endorsement that the affidavit had been duly affirmed, signed and verified by respondent before a notary. My lord, I ask myself, I pause and ask myself whether this is there in the present case. My submission is no. Under the affirmation by the notary, the words SD notary were also written. What was, however, found missing in the copy of the affidavit was the name and address of the notary, as well as the stamp and seal of the notary before whom the affidavit had been so affirmed and who had attested the affidavit. The defect found in the present case is almost identical to the defect which had been found in the copy of the affidavit supplied to the first respondent in the Anil R. Deshmukh case. The defect is materially different from the defect found in Dr. Shipra case. So here the defect is materially different. In Dr. Shipra, my lord, there was nothing. It was blank. The defect is materially different from the defect found in Dr. Shipra case, where the true copy of the election petition furnished by the election petitioner to the successful candidate did not show that the affidavit filed in support of the allegation of corrupt practice had been duly sworn or affirmed and verified by the election petitioner before a notary, whose attestation was also found missing. My lord, here everything is missing. At the bottom, there is a running signature, Tada Mangu. Now, what do we make of it? Pausing here, my only submission is even the Paulos doesn't help them. And this is the law of the land.
Let's have some,
I'll continue.
let's have some tipping.
Oh, yes.
How long will it take?
My lord, I have one more ground to urge. And
One more
after
ground?
Paulos, in that ground, my lord, I will place only one judgment. And that will be over.
Complete by
It will now be over by 2:30.
2:30, yes.
2:30.
I'll have to rise around 2:45.
Then my.
I will take around half an hour, I'll finish. Half an hour, 40 minutes.
No, I have this meeting fixed at 3 o'clock.
3 o'clock. Before that, I will try to finish.
Yes. If
Fine.
it is by 2:30
Both of us
and
will.
15 minutes.
Sure.
And if
I'll try to
you
finish
can
in 15
continue
minutes.
also. Are you comfortable tomorrow?
Tomorrow, my lord, will be a staff.
I will have to leave because there are two
No,
cases.
you-
One is part heard.
You complete your part.
I'll complete.
By 3:40.
By 2:15, 2:20, I'll
2:50
finish.
you complete.
We will try to finish it if it spills
By
over, my lord.
2:45.
If it spills over, my lord, tomorrow.
Yes. You can complete your part today.
Whether or not there was any other copy along with the election petition. The thing, it was all blank. This is what he found. That's number one. Number two, he also informed me that the copy which was returned unserved, it was kept in a sealed cover because it returned unserved, so there was a seal. The seal was not opened by the registry kept it as it is. He wanted to take that very particular copy, registry said, no, that is not possible. The copy you got the justice service, that is with you, you would not be allowed to see it. So that is under the seal cover, the copy which returned unserved. So that is the status.
It's still under the seal cover.
Yes, this is what he told me. He found it. Anyway, this is what he said. Mr. Lambu told me. So now, my lord, I come to the ground number 3. The ground number 3 deals with section 83, subsection 2. Namely,
'83 subsection 2.
yes. Any schedule, 83 subsection 2 reads, page 83, sorry, page 89 of the, I think we have the same copy, my lord, Representation of People Act, 2024 edition of Law and Justice,
Yes, yes.
page 89,
Yes, yes.
subsection 2. Any schedule or annexure to the petition shall also be signed by the petitioner and verified in the same manner as the petition. As the petition is election petition. Copy also shall also be signed by the petitioner and verified in the same. Now, my lord, here, not a single schedule, not a single annexure is signed by the petitioner. It's all blank everywhere. 83 subsection 1 deals with the contents of election petition, what it should contain.
Yes.
Now, in support of this proposition, my lord, I place one judgment. It is 1991, volume 2 SCC. 1991, volume 2 SCC, page 342.
So there's no signature or
No signature anywhere.
no
Lord, you could see
verification,
all the
nothing.
annexures.
Okay.
Any page, my lord, can see. For example, just for example, annexure 2, page 90. Page 95, annexure 4. Even the verification and affidavit in support of the annexure is blank. Every single annexure, no signature whatsoever. Even the verification and the affidavit in support of the annexure is also blank.
This is the copy sub on you.
Yes. In fact, that is the exact copy which I got, and photocopy of my copy is your lordship's. The relevant paragraph is paragraph 9 at page 347, Manohar Joshi versus Damodar Tatyaba.
There 9.
Yes, my lord, paragraph 9. The relevant portion is at Placitum G.
Yes.
Placitum G, just lordship would see schedules or annexures, whether my lord has got it. Placitum G, schedules or annexure to the petition in support of the correct practice. They have also to be signed by the petitioner and verified by him in the same manner as the petition. This is a mandatory requirement. This is what the Supreme Court says. In Tara 8, Supreme Court has quoted the entire section 83 and 9 of observations of the court. At Placitum G, the Supreme Court says that Para 9, this is a mandatory requirement. Every annexure has to be signed by the petitioner and verified by him in the same manner as the petition. Because the idea behind the whole thing is the person against whom the allegations have been made, he must have due notice. He must know it. It is not that, my lord, he will run around, he will try to verify, he will find out if it is the correct copy, if it is the incorrect copy. It is not for the petitioner to go and apply for a certified copy to understand the true picture. Unfortunately, my lord, this is what petitioner had to do in the present case.
Yes.
My lord, I rest my case here. So, my lord, I sum up. The first ground of attack pertains to section non-compliance of section 81, subsection 3.
Yes.
Namely, number 1, there was no attestation by the petitioner under his own signature to be a true copy of the petition, the copy which was served. And number 2, the copy did not bear any signature. So, section 81 subsection 1 as well as section 81 subsection 3, there is non-compliance of both. Section 81 subsection 3 second part and section 81 subsection 1. Section 81 subsection 1 pertains to 45 days time limit. The submission is within the period of 45 days time limit, the election petition which was not filed along with the copy to be served to the petitioner. It was when the my lord issued the notice, which was after the period of 45 days, they had taken steps and they went with the extra copy. That is a submission pertaining to 81 subsection 1 and 81 subsection 3, attested to be a true copy, signed by the petitioner. Nothing is there. That's ground number 1. The ground number 2 may not pertains to Form 25 affidavit, not notarized,
Section 83.
not attested, nothing.
Section 83.
Yes, my lord. No, ground 2.
Provided to section 83.
Ground 2, my lord, section 83 proviso. Correct. Form 25 affidavit.
Noted.
No. Ground 3, section 83, subsection 2,
Yes.
And Manohar Joshi case cited and relied on. That's
Has
also
to be
not an-
signed and verified.
Yes, that's it, annexures, because not a single annexure is signed and verified. Nothing is there. So, my lord, I rest my case here.
Yes. As you, for today.
That's,
For today.
I think I will not reply and all, I don't know.
Yes.
Subject to,
Yes, my lord.
my lord, may I take leave for some time?
Yes, yes.
My lord, after my.
Have preferred lunch and come.
Refresh myself.
After my learned senior colleague has placed the case, my lord. Now, I would like to start from certain basic facts, my lord.
Hmm.
First is, I will place the same sections, 81 and 83, in slightly different context. It has to be read with 86. That is the basic difference. Reading from the statute itself. We don't have to go to any case law. We'll come to the case law later. Your lordship, kindly have section 86 first, my lordship.
Yes.
Now, 86 says, the High Court, subsection 1, the High Court shall dismiss an election petition which does not comply with the provisions of 81, 82, and 117. So 83 is not mentioned in 86. So whatever is the requirement of 83, if that is not fulfilled, that cannot be a reason to dismiss an election petition. Those are procedural safeguards. There may be a delay or defect in that, but that cannot be a ground for dismissing the election petition. 83 that way is totally different from 81. Because your lordship will now come to 83.
Yes.
Yes. Lordship may kindly come to 83.
Yes.
83 subsection 1.
Contents of the petition.
Subsection 1.
Yes.
Subclause C.
Hmm.
It shall be signed by the petitioner and verified in the manner laid down in the CPC for the verification of pleadings. So if there is a defect in the verification, that cannot be a basis for dismissal because this 83 is not included in 86. So verification defect is not a ground for dismissing an election petition at the threshold.
Yes.
Second, my lord, proviso, provided that where the petitioner alleges any corrupt practice, which we allege in this case, the petitioner shall also be accompanied by an affidavit in the prescribed form in support of the allegation of such corrupt practice and the particulars thereof. That is Form 25. So even if there is a defect in that Form 25 affidavit, my lord, that cannot be a ground under 86 to dismiss because the power to dismiss at the threshold an election petition comes by
81 and 82 and non-compliance of 81 and 82 or 117.
Yes, that's the limited.
So in case if there is no compliance of section 83,
yes,
what is the remedy?
Remedy, my lord, first, it is curable, my lord. And if there is any consequence, my lord, that your lordship will decide finally after leading evidence, finally in the judgment, my lord, if there is any prejudice caused to them because of those defects. But it cannot be dismissed at the threshold. That's the difference, my lord, 83 and 81. Now, my lord, here, my lord, it is first, it is curable. Second, even if it is there, the decision whether there have been any prejudice on their part because of these defects, that will be decided by lordship whether finally after leading evidence and all. Now, my lord, kindly have 81. My lord, 81 is a provision which is included under 86. 81 says that the election petition may be presented to the High Court. I'm just reading the relevant part, my lord, because the election petition may be presented to the High Court within 45 days. That's the narration of 45 days from the date of declaration. That's the gist of this thing. It is to be High Court within 45 days from the date of declaration of the election. Now, as far as this 45 days is concerned, it's admitted fact
that on 2nd of June, the election took place and we have filed on 16th of June. So within 45 days we filed. 17th of June is the last day. So before, one day before, July. So I'm sorry. So, oh, list of date they were like that. So, my lord, on the face of it, my lord, there is a distinction between 81 and 83. 81, the second part, which is 81.3, which says that copies has to be signed and equal number of copies has to be submitted. That part, I will deal with that. This is a list of date I have just prepared for the court, just for our. This is your copy. This is just for the factual aspect, my lord. How things has happened in this case. Now, my lord, in 81 also, before I come to this list of date, my lord, one last submissions.
Yes.
Even in 81, my lord, there is substantial changes that has been brought in by the Supreme Court in various judgments, my lord. From 1963 till 2024, my lord. There are various judgments, my lord. I will cite some of them which are relevant, my lord. So the substantial difference is this, my lord. It says, if there is a substantial compliance, the phrase is, my lord, substantial compliance of 81. That substantial compliance is sufficient. One is substantial compliance. That phrase is very important, my lord. Second is vital defect. What is a vital defect? The vital defect is that because of that defect, they are not able to defend their case. They are prejudiced in defending their case. So therefore, these two principles has been introduced by case laws, my lord. I'm sorry. I will take your lordship through this now. So this is the difference, my lord, in 81 and 83, and 81 also, my lord, has been substantially diluted by from 63 to till date, my lord, by various judgments of Supreme Court. The main catchword is, my lord, substantial compliance and vital defect. Vital defect leading them not able to defend themselves. That kind of a defect. Now, my lord, lordship may kindly have the list of dates. So, my lord, 6th of June 2024, that's the first date, serial number 1. Election results were declared. Now, 16th of July 2024, election petition filed. 31st of July, my lord, the first time this petition was listed before your lordship, notice was issued. Number 4, 2nd of August, steps for service was taken by the registry. Now here, my lord, I will ask your lordship, I'll request your lordship, my lord, that there is a file noting prepared by the registry in the original file, the file notice. Because what they are,
in the election petition.
In the election petition. Because what is alleged, my lord?
Yes, what does it say?
You have the entire list. Entire list in place. I'm specifically referring to the notice 30th of August. 30 August. No, not 31. 30. 3008. You are reading that? Okay, okay.
30th August.
Yes, sir. As directed by the Honorable High Court, the learned counsel for the petitioner has taken steps upon respondent number 1 on 38/2004, and accordingly, the notice has been issued by memo number so-and-so, dated so-and-so, by Dusty Mode. And previous to that, my lord, 1st of August, one more note. I'm just showing what is the difference, because on 30th of August, we have taken steps because our lordship directed us to serve in Dusty, in addition to normal registered post. And then kindly have 1st of August. When initially notice was issued, what is the file note? As directed by the Honorable Court, steps to be taken by upon R number 1 on dated 1st of August 2024, and accordingly, the notice has been issued by memo number so-and-so dated so-and-so by registered post, court order reference so-and-so, my lord. So, my lord, kindly see 1st of August, there was no involvement of ours, the petitioners. The registry issued the notice and they have mentioned the reference number and all. It is only because when we have filed our petition in 16th of July, copies along with envelope and all the postage stamps were with the registry. It was filed along with the registry. And therefore, 1st of August, when the notice was issued pursuant to a lordship direction of issuing notice, there was no reference to the petitioner. It is by the registry had sent a registered post as per the rules. This is very important, my lord. Second, my lord, that's why I'm saying, kindly compare this with the 30 August 2024 noting, where the direction was given to the petitioner to serve them by the ST. So it specifically mentions that petitioner have taken steps. So these two entries, my lord, clearly show moving on.
31st July, there is a direction to take steps.
31st of July,
Petitioners to take steps for service of notice upon responded by registered post.
oh, so that was the direction, my lord, but as per the rules, I will place the rules also.
Yes.
It has to be done by the registry because already the petitions and everything was before the registry. The copies, extra copies, along with the envelopes, as per the rules were with the registry. Therefore, registry, after your lordship direction, says that we have issued the registered post to the respondents. So that is the noting. 1st of August, that is the noting. There is no involvement of the
See, registry will issue a notice on your furnishing or taking steps.
Exactly.
You will have to furnish all those.
Exactly. So therefore, my lord, the question now is on 16th of July, whether we have filed it or not filed. That is the question, lord. Now, only thing they are, the other side alleging is that you have not filed it. The onus on this account is on them to show by positive evidence that no copies were filed. And in addition to that, this is one point, the onus, they have not discharged that onus, because they are only alleging that 16th of July, we have filed only one copy and rest of nothing was filed. So that onus has not been discharged by any positive evidence by them. Secondly, my lord, there is a presumption in favor of a official work done by any government office, including the registry of this High Court. Now, Evidence Act 114E, my lord, there is a presumption, and I will back it by case laws, my lord. In such allegations have been taken in other cases also. When the Supreme Court has said, first the onus is on them, and there is a presumption in favor that it was done in the manner prescribed. Because your lordship will now kindly have a look at the checklist of this file. There's a checklist also when we file it. The oath commissioner would say the assistant registrar, come oath commissioner, come stamp reporter has placed a checklist. Top. Lordship has that. It is dated 16th of July, 2024, second page. Lordship will see various things is mentioned, my lord. Serial number 1, properly addressed to the court, not is striked out. Serial number 2, the petitioner is typed, not is striked out, is typed in eligible double space, which is the requirement of the rules. Now, my lord, kindly have all those 3, 4, nothing is there. So it presumes key whatever is there is correctly done. Number 9, Vakalatnama file, not is striked out. Affidavit file, Vakalatnama is also filed. That is mentioned. Now, next page. 14, requisite court fee, ₹20, file. And number 18 is also relevant, my lord. Notice not served on the respondent, because that time notice will not be served. Only when your lordship issues notice, it will be served on them. 19 is important. Copies of petition insufficient. It is not ticked or anything. They have not said it is insufficient or anything. Now, below that, my lord, below that, a challan of 2,000 deposited in SBI as security for the cost of the petition. See, Guwahati High Court Rules, Chapter 8A, Rule 1A has been filed along with the petition. We even filed the rules for the stamp reporter and the assistant registrar to comply with the rules. My lord. He has recorded it and he has put his signature. His date is there. Case ready. It is shows defective. So, my lord, this with the fact serial number 19, copies of petition sufficient. There is no remark there against that. It is insufficient. So this document is a government document. It's a document of the court, which is done in the official course of the business of the court. This has a protection. This is a presumption that it is correctly done. Anybody disputing this, my lord, has to bring in evidence. The onus is on them to prove that this is not correctly done. And this followed by the file noting I have shown, my lord, 1st of August. So, my lord, till this time, my lord, I have shown, my lord, the checklist and the file noting. So the checklist has a presumption. One, I'll place the judgment also has a presumption. Unless they rebut that presumption, my lord, they put positive evidence to show it was not done in the manner it is written there. So then I have a case to defend myself. But it is only an allegation as far as first allegation that copies were insufficiently filed. So right on this, my lord, I will just place one judgment so that it concludes the issue. 2005.
This High Court rule need to be filed along with this.
No, it need not be filed. We have given him a copy so that probably, my lord, it was not there at the office. So we have given a photocopy so that it can be seen and compliance can be seen of the election petition. That must be the idea. Because everything was done in the chamber of the assistant registrar, who is also the stamp reporter, who is also the oath commissioner as per the notification of the Guwahati High Court. So therefore, the petitioner personally came before the in the office of the assistant registrar. He put his signature in front of him, and entire petition along with the
So
copy.
according to you, on 16/7,
Yes.
You have filed the
Yes. Yes.
requisite
Copies with all necessary requirement under section 81 as well as 83. What happens subsequently, I will come to that. On 16th, I'm only dealing with 16th, the filing date.
Yes.
So one judgment. Sir, could we copy it?
Yes.
तो इसमें कुछ पैरा ये जस्टिस सिन्हा का लास्ट में शायद एक पैरा है ना
Yes.
Yes, my lord. 85 billion 22. Lord, kindly have para 22 of this judgment. This is a judgment of 2005 by 3 judge bench.
22.
20 para 22, yes, my lord. It is an admitted position that true copies of the election petition were served on the respondent number 1 by the court plaintiff in absence of any material to show. I think this is not the paragraph. I think, yeah, which one? Sorry. Lordship, my father, in the absence of any material to show that the true copies of the election petitions were not filed with the election petitioner at the time of their presentation, and in view of our discussion herein earlier that no reliance could be placed on the copies of the reliance of the High Court, were unable to sustain orders of the court. Now, your lordship can kindly 26. 26. No, this is not the one. I want to show that 116. I'm just coming to that. Lordship, give me one moment. I have seen that. This is para. Lordship, make straight away come to para 85. This is a concurring judgment by Justice S.B. Sinha.
Para
85.
85.
85. On this issue, the onus is on them, and there's a presumption. Consideredly, the officers of the High Court are required to perform administrative functions, one of which is to scrutinize the election petition so as to ascertain as to whether petitions filed before the court are free from any defect. Such an official act would draw a presumption of having been performed in the ordinary course of business in terms of section 114E of the Evidence Act. So therefore, my lord, it's clear that there is a presumption in favor of these documents which I have placed, the checklist and the file notings. Owners के बारे में एक पैर. And your lordship can also see yes, para 26 also lordship may see. Last line of para 26, just above 188, page 198. It is no longer res integra. Lordship has that page para 26, just above 198. It is no longer res integra that the onus to prove that a copy of election petition is not served on him must be on the person who alleges such fact. We are therefore of the view that in the absence of the endorsement in the presence of the endorsement of the assistant registrar of the court dated so and so that the election petitions were in order, which would arise a presumption. It would be for the successful candidate respondent number 1 to rebut such presumption and discharge his initial burden. So this is the crux of the matter, Lord. Then they go into the facts of the case of that case. So two propositions, my lord, presumption and discharge. Naturally, my lord, when presumption is there, my lord, legal presumption, then they have to rebut. What they are rebutting, my lord? The rebutting is like this, my lord, key inspection has been done. There is nothing. There will be nothing because that has been sent by registered post. Okay. My lord, on this, I will place a note also after my submissions, my lord. So one more paragraph I just want to, because since we are in this judgment, it's very important judgment, my lord. Para 81, my lord.
81?
81, yes. And 82 also. What is it? Para 81, my lord, I will just read out. However, herein, the binding decision of the Constitution bench in Murarka, Radhesham and Chandra Subbarao were not noticed. Satyanarayan and Rajendra Singh, therefore, in our opinion, do not lay down good law. So these are the two judgments which my learned friend has relied. The first two judgments, my lord. So the first two judgments, my lord, is Satyanarayan is 1974, 4 SCC 237. And the second judgment, my lord, is 1984, 3 SCC, that is Rajendra Singh, my lord. So since we were there, my lord, I am placing this and one more para, 82 also. In somewhat similar view appears to have been taken in Dr. Shipra and Shantilal Kudwai, but in Anil Deshmukh, the court doubted the correctness of law rendered herein and held that there was a sufficient compliance with the provisions of subsection 3 of section 81, which would serve the legal requirement. So even Shipra, my lord, in a series of judgment, my lord, they have said this is not a correct proposition, what has been held in Shipra. This was also, my lord, was placed before your lordship. So I just wanted to, since we are here, my lord, to begin with, my lord, I just wanted to point out that what has been shown may not be the right correct position, my lord. Now coming back to my list of it. I'm conscious of the time, my lord. I will not be able to finish it today. That's my honest confession, but I will proceed as per your lordship. No, now let me come back to serial number 6, my lord. Serial 6 is the dusty notice prepared and handed over by the registry, my lord. So that your lordship has seen, my lord, the file noting that it was given to me. 7, registered notice, returned answer. So when the dusty notice was given to me, my lord, that time, the registered post, which was sent on 1st of August, that has not come back. It has come back 1 day later. This is all from the notings, file notings. Now, I have got a dusty notice. I went because I can't have a copy, exact replica, because I have filed 2 copies. One is before your lordship, one is in the registry for service. Now, when I get a dusty notice, my lord, I don't have a copy because I cannot create the same, because the reason is, my lord, the affidavit is of 16th of July. I get a dusty notice on August, 30th of August. So I cannot go to the old commissioner and say, give me a backdated notary. It can't happen. So therefore, my lord, whatever I had, I have produced along with the dusty notice. I have sent him, because creating that and putting my, a affidavit, a notarized affidavit at that point in time would be, a delay. And therefore that could not have been done. I could not have created the same copy because I have deposited the copy. And one more interesting part, my lord, when your lordship said dusty notice, that order is very important, my lord. Kindly have that order of 22nd of August. Yes, my lord. That says, part so and so, 22nd of August, my lord, serial number 5. It is noticed that those steps have been taken by the petitioner for service of notice upon the respondent, same yet to be served. Second line, awaiting service report in respect of the respondent number for further 20 days, the learned counsel for the petitioner is permitted to take steps through dusty mode. List on 11/9/2024. So therefore, your lordship has not suspended the normal course of service. The normal course of service is registered post, through registered post, they will be served the true copy. That service is going on. That has not been suspended. That another 20 days, your lordship has extended the time. In addition to that, my lord, substituted service through dusty means was given to us, just to an intimation to the respondent, the matter is pending. It is not in substitute of the primary service under the rules.
Then,
so therefore, my lord, both the services are going on parallel. When I serve him on 1st of September, according to them, my lord, even the registered post was supposed to, because I don't have a copy, because the registered post has not come back when I got the dusty notice. So whatever copy I gave him, and then he appeared on 11th of September, the next date fixed, he appeared before this court, my lord, and he sought time. He sought time for filing. He did not ask for a copy. He didn't say that the copy he has received is defective. He didn't say, okay, I want to give me a fresh copy, nothing of that sort. He appeared and he said that I want time for filing reply. And on 24th of September, the next day, serial number 10 of the list of date, he files these applications, 711 and 616. Both the applications are filed. So now the question is, my lord, what happened between 11/9 and 24 September? Because there is a gap of 24 days. 1 minute. So it can be 19 also, 8, serial number 8 and serial number 10. So he got a copy, he appeared, and then he files. So his own admission in his WS, my lord, that he has got a certified copy in between and he has prepared his defense on the basis of that. And in this IA also, I will show one paragraph, my lord. Here also he states that he has, from the records of the registry, I find this. So he has inspected the file. He has seen it. So therefore, whatever defects, my lord, he is saying, that defect, once he inspects, once he gets the certified copy, so that defects is taken care of. Even if there, I am saying, I'm not admitting that there is any defect. I will come to that. But their own conduct, they have shown, my lord, they have inspected and they cannot now say I am prejudiced. Huh? They are now misled because they have inspected the file, they have got certified copies. They have, based on the inspection, they have filed their reply, also their IAs also and the replies also. So this is the basic facts, my lord, based on which, my lord, I will make my submissions, further submissions, because the second page is the, Lordship may have the second page. I'll just narrate because hardly 5 minutes is left. Lordship has to go to a meeting. I'm conscious of that. So next page, my lord. So as I said initially, my lord, there are two types of defects. One is under 81 and one is under 83. This A 1 to 3 is the allegation under 81. So I will deal with them, my lord, one by one. And next page is B. These are the allegations, my lord. These are under 83. So I've already pointed out, my lord, any defect under 83. So it's like true copy not mentioned. No endorsement on Form 25. Unsigned annexure. Security deposit. So these are not on the basis of which a 711 can be maintained. These are not defects on which at the very beginning, at the very threshold, the election petition can be dismissed. Under section 83. These are defects under section 83. And coming back to the allegation 1, which I will deal on the next date of AM. No stamp reporter, required number of copies, and delay in filing. I will deal with judgments, one by one. These are the three major, according to me, is the submissions, and my learned colleague has also placed those judgments also. I will deal all of them. I will place a summary note also, and I will finish it on the next date.
We'll continue tomorrow.
Tomorrow, I think.
My difficulty is there are two parted cases before the principal.
This also will keep it part. It's an election petition. First preference has to be given to this.
Over there, that will be a catastrophe because Justice Devashish Barua will end up, taking it up ex parte. So I'll be in a problem. But here is a case.
No, so far as there is 183 is concerned, I've heard you.
True, that's true, but here is a case.
Only maybe
Assistant registrar.
you need to reply.
Yes,
that's all.
Yes, because reply, can I give a reply?
So can you continue tomorrow?
Tomorrow it will be little difficult, my lord.
Then
may I suggest?
If it is not tomorrow, then after a week or so. Or next week.
Next week, if I have to come, I'll come.
Yes, I will come. We'll be here. 29th, it will be.
Oh, yes, perfect.
Perfect.
29?
29. Lordship is here, yes, as per the roster.
29, I'll be there, but thereafter I'll again fly. I have to fly.
We'll finish it. We'll finish it.
Finish it on 29.
For the benefit of my friend.
Yes, of course.
I'll be
All
asking.
is well.
Yes.
All is well.
I'll be asking for the recording of the evidence of assistant registrar. Because here the registry, the relevant column is blank. It is not an endorsement. Leaving the column blank is not an endorsement. As to whether or not the copy was deposited on the 16th of July. That's point number one. And that's why, I'll be asking for the deposition of the assistant registrar. If they have made a mistake, they should understand that. Because the degree of arrogance is there in these people. When my assistant colleague is telling me he requested them asking for the copy of the checklist, they said nothing to it. He asked for the copy, which was within the sealed cover. He said it is meant for us, kindly give it that. They refused. I'll be asking for the deposition.
I don't want to get into this allegation.
But allegation, negative can't be proved. So negative, I'll be placing judgments on that.
It's not negative, it's a positive.
The positive evidence on something which was not done cannot be there.
It's
As
okay.
per the law.
Then
We'll
we
argue.
in case we are not able to take it up today, so we'll.
So
we'll
I
fix
understand,
it,
okay, 29.
29th. Grateful.
Heard Mr. The the argument of learned senior counsel, Mr. PK Tiwari for applicant public respondent is completed.
Yes.
Yes, reply only.
Is completed.
Rituraj Biswas.
The however, argument of Mr. Rituraj Biswas that concept of opposite party election petition remains inconclusive. List of on the joint prayer of that concept of the parties, hearing shall continue. List the matter for further hearing on 29,
Yes.
11/20.
It's getting
At
interesting.
least one by one will.
Yes. It's
try
getting
to
interesting, my lord.
finish it
Normally,
one by one.
after 7 to 11 application arguments of this nature and the nitty-gritty, at least for this portion of our country, these things normally do not happen. So let us see.